Daniel, let's start with the text that everyone quotes. All persons born are naturalized in the United States, and subject to the jurisdiction thereof. The hinge is subject to the jurisdiction. If that phrase meant full political allegiance, as some originalist readings argue, then Congress can rationally define citizenship to require a parental tie to the polity. Other common law countries have moved in that direction without democratic collapse. Why must we treat blanket jus soli as sacrosanct? Marcus, because the same text, history, and practice you invoke cut the other way. The Reconstruction Congress was explicit. The citizenship clause covers nearly everyone born on U.S. soil, save narrow exceptions like diplomats. That is how the Supreme Court read it in the 19th century, and the country has operated on that basis ever since. Altering the rule now would create a class of native-born non-citizens and inject uncertainty into a status that's supposed to be clear and equal from birth. Daniel, equality isn't the only value. Consent matters. Citizenship creates reciprocal obligations. A parentage-based requirement aligns membership with a minimal, intelligible connection, lawful presence or citizenship of at least one parent. It also answers concerns about birth tourism and incentives that a pure territorial rule might create. If we can reach the same civic ends with a rule that better fits allegiance, why not? Marcus, because you don't reach the same civic ends. A parentage test would require massive documentation and constant policing at the delivery room, the schoolhouse, and the passport office. Think about the administrative state you'd build to verify parent status at a child's birth, then to re-verify when disputes arise. You'd invite mistakes, inequalities, and litigation. The current rule is simple, administrable, and egalitarian. Born here, you're in. Daniel, simplicity is attractive, but the question is constitutional meaning first, policy second. The jurisdiction phrase didn't come out of nowhere, it reflected notions of allegiance that excluded certain categories. When the nation's circumstances have changed dramatically, a recalibration may be not only permissible but appropriate, especially if Congress legislates a narrow, prospective rule with generous safety valves. Marcus, those safety valves are where equality dies. The country fought a war to end hierarchies of status by birth. The 14th Amendment was designed to anchor equal citizenship in a bright line. You're proposing to replace that with a conditional system that would inevitably fall hardest on the poor, the undocumented, and communities with complex documentation histories. It's not just a legal question, it's a civic message. Some natives belong less. Daniel, that's rhetoric, not inevitability. A carefully drafted statute could grant citizenship at birth when at least one parent is a citizen, permanent resident, or long-term lawful resident, and provide streamlined registration for others who grow up here. It would align membership with genuine connection and blunt the incentive to game the system. Marcus, you've just admitted the endpoint. Most of those kids would become citizens anyway. So why force them and their families through years of limbo? And your gaming frame ignores the overwhelming reality that most people who give birth here are not gaming anything. They live, work, and raise children here. Your fix imposes risk and stigma to solve a problem you haven't shown is systemic. Daniel, I'm not claiming a crisis. I'm claiming a mismatch between rule and principle. Citizenship is the ultimate political good. It should rest on an intelligible bond. Even if the vast majority of cases wouldn't change, setting the rule correctly strengthens the meaning of membership and the nation's capacity to self-define. Marcus, the nation already self-defined, in the Constitution, in the aftermath of slavery, and through a Supreme Court decision that every administration for a century accepted. The bond you want is already there. Being born under U.S. peace and protection is a real bond. You want a different bond, parental status, and to get it you create non-citizen natives who are Americans in every way but paperwork. That's corrosive of civic equality. Daniel, then meet me halfway. Suppose we maintain jus soli for nearly all, but clarify that temporary diplomats and limited other categories are excluded by statute. At the same time, we crack down on predatory, birth tourism, schemes. That preserves the bright line while addressing the legitimate concerns that drive the reform side. Marcus, I can live with enforcing the existing, narrow exclusions and prosecuting fraud. That's different from rewriting the rule of who is American. And we should invest in administrative competence where it's genuinely needed, identity protection, secure vital records, without weaponizing citizenship. Daniel, there's another angle, national comparators. The UK and Ireland limited territorial birthright without abandoning liberal democracy. That suggests reforms are administrable, not dystopian. Marcus, comparators cut both ways. Those countries also built extensive registration regimes and still face contested edge cases. More to the point, our constitutional text is different. Our history is different. Our race history is different. Importing their model ignores the particular wrong the 14th Amendment was designed to cure, caste by birth. Daniel, fair. But I still think the text's jurisdiction phrase leaves room to debate. If Congress acted, the courts could give us clarity that scholarship alone cannot. Living under a contested reading for decades doesn't serve anyone. Marcus, the courts have spoken. What you're proposing is not clarification, it's reversal. And reversal would not be neat. Families divided in status, kids discovering in college that they are not citizens, bureaucratic burdens cascading into daily life. The cure would be worse than the disease. Daniel, then here is where I land. The principled route is a parentage anchor with humane on-ramps. The pragmatic route is tightened enforcement against fraud with the current rule preserved. I prefer principle, but I'll accept pragmatism if we can name the concern. Marcus, and I'll say the principled route is the one we already have, citizenship as equal birthright, paired with better administration. We can fight fraud without relitigating the settlement that made us a civic, not hereditary, nation. Daniel, we may not persuade each other, but we've narrowed the field. The live choices are, keep jus soli and improve execution, or pursue a narrow statutory redefinition and accept the constitutional fight and administrative costs. Marcus, and the public should judge each path against two tests. Will it keep citizenship clear, equal, and secure? And will it avoid manufacturing a class of Americans without a country? On those tests, I know which way I'd vote. Daniel, and I know mine. At least we agree the stakes are high enough to demand candor and care.